Good afternoon and welcome to the City of Richmond Rent Program's Understanding Eviction in Richmond workshop. My name is Palomar Sanchez. I'm one of the staff attorneys for the Richmond Rent Program. And thank you for checking out our workshop. And if you have any questions, you can always call us, email us, or set up an appointment to discuss any questions that you may have following this presentation. All right, so this is Understanding Evictions in Richmond. First of all, actually, before I get to this ordinance, I wanted to just say that the best advice I can give in any eviction-related issue, whether you're a landlord or a tenant, is to speak to an attorney. The reason being is that our program cannot provide legal advice, and especially because evictions are a legal proceeding, you definitely want to speak to an attorney about any information in this presentation, as well as your case. So that is, before I get started, is my number one piece of advice, which is speak to an attorney, specifically one who's familiar with unlawful detainers and eviction. All right, so first of all, I just wanted to mention that the City of Richmond has passed an urgency ordinance on March 23rd, 2021. The Richmond City Council adopted urgency ordinance number 02-21, otherwise known as an eviction moratorium, establishing a temporary moratorium on certain evictions of residential tenants in Richmond through the, quote, local emergency and 60 days thereafter. While the urgency ordinance is in effect, landlords are prohibited from evicting tenants in most circumstances. Please review the ordinance on our website if you have any questions. The link to the that specific ordinance is under our COVID-19 rental related information page. All right, so this is just a brief overview of the Richmond Rent Ordinance. First of all, we have rent control, which means that rents are regulated. The maximum allowable rent is calculated by taking the base rent, adding annual general adjustments, or otherwise known as cost of living or inflation rate increase, and then any allowable individual rent adjustment that is ordered by a hearing examiner. Of course, this is following that the landlord filed a petition and then the decision was ruled in their favor. So the base rent. So what is the base rent? The base rent is the rent in effect as of July 21st, 2015. So that's for older tenancies. For newer tenancies after that date, it's the first rent that was charged for tenants that moved in after that date. The annual general adjustment, otherwise known as the AGA, represents 100% of the consumer price index in the Bay Area, otherwise known as the inflation rate. And then there's the petition process, which is a mechanism to increase or decrease the MAR, which is the maximum allowable rent, based on reasons permitted by the rent ordinance. Then the other kind of half of the Richmond Rent Ordinance is the just cause for eviction protection section. So a landlord needs to have or cite one of the 8 just causes to terminate the tenancy. Now, bear in mind that there's a bit of a caveat to that, given the urgency ordinance that I mentioned in the previous slide. But still, in just normal times and under our ordinance, a landlord still needs to have at least one of these 8 just causes. And so the 8 are as follows. First is failure to pay rent. Second is breach of lease. Third is nuisance. 4 is failure to give access when the owner or landlord has a lawful right to do so. 5th is to temporarily vacate the tenant in order to undertake substantial repairs, but that's a temporary eviction. The tenant has to be let in after the work is done. An owner move-in or owner relative move-in eviction, withdrawal from the rental market, otherwise known as the ELLIS Act, and temporary tenancy. And so just back to this urgency ordinance 02-21, it does prohibit most evictions such as owner move-in. So that's something to be aware of. So which properties are covered by the rent ordinance? So you have fully covered well, otherwise called controlled rental units, which means that they have rent control and just cause for eviction protections. Some examples of this would be multi-unit properties built on or before February 1st, 1995. So most apartment buildings are going to be fully covered. Then there's a second category called partially covered. So this means that only the just cause for eviction protections apply, but the rent is not controlled. So it's not rent control. Some examples of this designation would be subsidized units, including Section 8 tenancies, properties with one dwelling unit on one parcel, like a single family home, condominiums, or new construction, which is anything that is constructed on or after, or excuse me, after February 1, 1995. And Costa-Hawkins, this is a state law, requires that these units be permitted with a certificate of occupancy in order to be considered new construction, i.e. that the permits are final and the unit is fit for residential habitation. And the final category is fully exempt, which means that there is no rent control and no just cause for eviction protections. It's kind of as if the property is just not in Richmond at all in terms of the rent ordinance. So some examples of this would be where the landlord and the tenant share a kitchen and or a bathroom. Single family homes where a permitted ADU, an accessory dwelling unit, was added and the main house is owner occupied, or retirement homes. All right, so compliance with the just cause for eviction requirements. So we're going to talk about the just cause for eviction, eviction noticing requirements, and then the eviction process itself, briefly. All right, so as stated before, residential tenants can only be evicted for one of the following just causes, and notices must state the reason. One is failure to pay rent after having been served a 3-day notice to pay or quit, breach of lease, and by the way, failure to pay rent is a bit more complicated given the pandemic and the passage of the state's COVID-19 tenant rent. See, I'm getting confused on the names again because it's been so long, but essentially the COVID-19 related state legislation in regards to non-payment of rent eviction. So there are additional requirements for those. Then there's breach of lease. So if a tenant continues to violate the lease after being warned in writing to cease the violation. Nuisance, which is essentially a catch-all, it can mean numerous things. If a tenant continues to cause a nuisance after being warned in writing to cease causing the nuisance. Failure to give access, if a tenant continues to deny a landlord or their agent lawful entry per Civil Code 1954 after receiving a written warning to cease denying the lawful entry. Temporarily vacate in order to undertake substantial repairs, owner move-in or owner relative move-in, withdrawal from the rental market, otherwise known as the ELLIS Act, and a temporary tenancy, which is only specific to single-family homes where the owner wants to rent out the home for up to 12 months, but then wants to move back in after that 12 months. And those asterisks there on the temporarily vacate in order to undertake substantial repairs, owner move-in, and withdraw from the rental market simply means that there's a relocation payment required per the City of Richmond's relocation ordinance established by the City Council. All right, so these are the written warning notice requirements under our ordinance. So first of all, for the just causes of breach of lease, nuisance, and failure to give access, a written warning notice must be served prior to a notice of termination of tenancy if the just cause is any of those three. This notice must provide the tenant with a reasonable period of no less than 5 days to correct the violation prior to serving a notice of to terminate the tenancy. It must state that the failure to cure may result in an eviction. It must inform the tenant of their right to request a reasonable accommodation. Shall include the contact number of the rent program, shall include instructions for compliance, and shall include information necessary to determine the date, time, place, witnesses present, and other circumstances. And we actually have a template available on our website at that URL address at the bottom of the page. All right, so the just cause for eviction noticing rules per Rent Board Regulation 1001. So for landlords who are landlords of property subject to the just cause for eviction sections of the rent ordinance, the landlord must submit a copy of any termination of tenancy notice served on a tenant within 2 business days of serving a tenant, along with a proof of service. And we have template proofs of service on our website available to the public. The termination of tenancy notice should be submitted online, and we have a website there where you can actually go online, set up your portal file and then upload any notices. And for properties with 5 or fewer units, the landlord may submit the notice by mail. And failure to file the termination of tenancy notice timely may be asserted by the tenant as an affirmative defense in an unlawful detainer, or otherwise known as an eviction proceeding. So it's super important to make sure that those notices are sent to us within the requisite time period. All right, so we discussed what is just cause, what is not just cause. So not just cause in the city of Richmond is the mere expiration of a lease agreement, especially where the contract says the tenant must move at the end of the lease. And what else is not just cause? The sale, transfer, or foreclosure of the property. Just because you sell the property does not mean you can evict. What else is not just cause? The tenant is paying below market rent and the landlord wants to evict the tenant to reset the rent. Not just cause is if the landlord makes a unilateral, meaning one-sided change to the terms of the tenancy. The tenant violates that unilaterally imposed term. And finally, what else is not just cause? If the landlord unreasonably denies a replacement of roommate, a 1-for-1 replacement, and then tries to evict for subletting or subleasing. And this is not an exhaustive list. There are others, obviously, but just wanted to give you a snapshot. So let's talk about the COVID-19 Rental Housing Recovery Act and non-payment of rent. So on or about June 28, 2021, the California legislature passed the COVID-19 Rental Housing Recovery Act, also known as AB 832. Under this act, landlords seeking to evict based on non-payment of rent between October 1, 2021 and March 31st, 2022 must comply with several additional requirements when filing an unlawful detainer. Between October 1, 2021 and March 31st, 2022, landlords seeking to evict for non-payment of rental debt that accumulated due to COVID-19 hardship must file with the court, in addition to any other requirements by law, any of the following statements under penalty of perjury, including, but not limited to, and this is all under California Code of Civil Procedure, section 1179.11. So these are the 3 statements that for evictions having to do with rent within that time period, you have to submit at least one or more of these statements. So 1, a statement that before filing the complaint, the landlord applied for government rental assistance, but the application was denied. A copy of the final decision from the pertinent governmental assistance program that their application for government rental assistance was denied. 2, this is a different statement. Before filing the complaint, the landlord submitted a completed application as defined in section 50897 of the Health and Safety Code for rental assistance to the pertinent government rental assistance program to cover the rental debt demanded from the defendants in an unlawful detainer, usually the tenant, in the case. 20 days have passed since the later of either the date of the application for rental assistance or the date the landlord submitted to the tenant with a 3-day notice underlying the complaint. The landlord has not received notice or verification from the pertinent governmental assistance program indicating the tenant submitted a completed application for rental assistance to cover the rental debt demanded, and the landlord has received no communication from the tenant that the tenant applied for government rental assistance to cover the debt demanded. And the third statement is that as a statement under penalty of perjury that the rental debt demanded from the defendant in the complaint accumulated under a tenancy that was initially established on or after October 1, 2021. And a note for that, if that is what happened, basically that the tenant didn't pay for any months after that October 1 date, that means that the summons on a complaint issued pursuant to that paragraph shall not be construed to be subject to the complaint to those, shall not be construed to subject the complaint to these requirements. So essentially that the rule is slightly different for evictions based on non-payment of rent that accrued on or after October 1, 2021. So basically, or excuse me, if it was the tenancy that was initially established on or after October 1, 2020. All right, those statements that I just read under penalty of perjury described above shall be made on a form developed or revised by the judicial council for this purpose if the judicial council determines that this requirement is necessary to accomplish the purpose of the statement. So it's possible that the judicial council has established these forms, although I don't know. If not, then you can essentially quote that verbiage verbatim from the law. If the criteria for issuance of a summons pursuant to subdivision A of 1179.11 as stated above has not been satisfied within 60 days of the complaint's filing, the court shall dismiss the action without prejudice. So that means your case, if you don't submit these documents within 60 days of the complaint's filing or with the filing, then your case is going to be dismissed. Without prejudice just means that you can do it again, but you will have to start from ground zero. In addition to the summons, the complaint, and any other required document, the landlord shall serve the tenant with copies of any of the aforementioned statements and final decisions filed with the court. The absence of these copies shall be sufficient grounds to grant a motion to quash service of the summons. So basically, you have to give if you're a landlord, you're trying to evict for non-payment of rent, you have to serve the tenant with whatever statement you submit and other documents to the court. And so if you don't, the tenant could file a motion and say this is insufficient, and your case may be dismissed. Non-payment of rent related resources for landlords and tenants. So this is an important part if you're looking for further information about non-payment of rent related resources. So as I said before, we have the Richmond Rent Program has a COVID-19 rental related information page, and there's the website. We also have a fact sheet regarding local and state laws concerning evictions and other related matters during the COVID-19 pandemic. And so we have them both in English and in Spanish. And then for information and to access the State of California Rental Assistance Program, you can visit our website there at the bottom. You can also go directly to the state's program, which is called Housing is Key. I think it's housingiskey.com. And they have the ability to process an application online in English and Spanish and other languages. So again, housingiskey.com. Okay, so here is a snapshot of the process, how an eviction works in court. Now, obviously, there's quite a lot of nuances to this, but again, this is just to give you like an idea of how these things go. So first of all, you start at the top left corner. The tenant has failed to pay rent. The landlord serves the tenant with a notice to pay rent or quit. The landlord must file a copy of this notice within the 2 days, right? Failure to do so is a defense. The tenant, and then it goes on. It says, okay, well, the tenant fails to pay the rent within the noticing period. The landlord then files the unlawful detainer, or otherwise known as the eviction lawsuit. The tenant must respond with their affirmative defenses within 5 days. And then if they do respond, then the court mails out a notice of the hearing or trial date. And then a judge or jury trial is held, usually after some type of settlement conferences, that kind of stuff. If the tenant fails to respond within that deadline, then the landlord can actually file a request for a what's called a default judgment. And if approved, the default judgment is entered against the tenant. And then if the tenant doesn't move voluntarily, the landlord will ask and will receive a writ of possession, and they can give that to the sheriff, and the sheriff will then serve the tenant with a notice to vacate. I'm not sure of the exact time period of how much that notice is, but it can vary. But then after that, the sheriff then evicts the tenant, and the tenant is escorted from the property. All right, so let's just briefly discuss no-fault evictions, such as owner move-in and withdrawal from the rental market. Again, owner move-ins are currently prohibited with the City of Richmond's urgency ordinance, but we'll discuss them anyway. So eviction for owner or owner relative move-in. So this is where the owner wants to recover possession of the rental unit as a primary residence for the owner's spouse, children, parents, or grandparents. An owner in this section is considered an actual person who has at least 50% recorded ownership. An eviction for owner move-in cannot occur if the same owner or chosen relative already lives in a unit on the property, or if a vacancy already exists on the property. So basically, if they live there already, you can't choose a different unit, or if there's an empty unit, you can't do an owner move-in. At all times, an owner can request a reasonable accommodation if the owner or chosen relative is disabled and another unit is necessary to accommodate the person's disability. Tenants have a first right of refusal to return if the rental unit is ever placed back on the market. And that's an important, so after let's say the owner lives there for 3 years, which is the minimum amount required, and they want to put it back on the rental market, they would have to contact the tenant and say, hey, this unit's available, would you like to move back in? Now, if it's a rent controlled unit, my understanding is that the rent cannot be market. You'd have to take what they were paying, add any annual general adjustments, and that could be their new rent. The tenant must be served with an owner move-in notice, which is termination of tenancy. Usually owner move-in forms may be downloaded from our website. Owners must give a tenant at least a 60-day written termination notice if the tenancy has been in place for more than 1 year. If it's a year or less, then it's only 30 days. And then within 2 business days after serving the tenant a termination of tenancy notice, the landlord must file a copy of the notice with the rent board with the completed proof of service. Failure to do so renders the notice of termination null and void. All right, so these are the owner move-in requirements. So first of all, the person moving in shall move into the rental unit within 90 days after the tenant has vacated and must occupy the unit as their primary residence for at least 36 consecutive months, 3 years. The owner must pay as I said earlier, this eviction requires a relocation payment to be paid to the tenant, and the owner must pay 1/2 of the applicable relocation payment within 3 business days after the tenant has informed the owner in writing when the tenant plans to vacate the unit, usually by the expiration of the notice. And then the remaining half is due within 3 business days after the tenant has actually vacated the unit. If the owner or chosen relative fails to occupy the unit within 90 days after the tenant vacates, the owner shall, 1, offer the unit to the tenant who vacated, and 2, pay the tenant all reasonable expenses incurred in moving to and from the unit. Now, for rent-controlled properties, this is fully rent-controlled properties, if the tenant moves back to the property or the first intervening tenancy, meaning whoever moves into the property after the owner or the relative moved in, they put it back on the rental market, the rent charge must revert back to the level paid by the displaced tenant, and the owner may be eligible to apply applicable annual general adjustment rent increases. But again, you cannot go to market. And I think that's the key. Landlords must provide tenant with proper noticing requirements for any rent increases. Non-rent controlled property, if the tenant moves back to the property, the owner may apply rent increases. Landlords are not restricted to the AGA rent increases, and a landlord must still provide the tenant with proper noticing requirements for any rent increases. Protections for seniors or disabled persons from an owner move-in. So even though this is a just cause, there are certain situations where a tenant may be insulated from this type of eviction. So an owner may not evict a tenant through owner move-in if the tenant meets the following criteria. 1, they have resided in the rental unit for at least 5 years. And 2, that tenant or one of the tenants is at least 62 years old, disabled, or is certified as being terminally ill by the tenant's treating physician. Now, that said, an owner may overcome these protections and may evict a tenant who is protected if the owner or chosen relative also meet the same criteria and no other units are available. What I think that means is, obviously, the same criteria is not exact because they couldn't have resided in the unit for 5 years. That's the purpose of the owner move-in. So they're not actually living there. I think what it means is they're 62 years of age, they're disabled, or they're certified as being terminally ill. In those situations, if the landlord qualifies under those categories, they may be able to evict the tenant for an owner move-in. All right, so let's talk about the ELLIS Act, which is otherwise known as withdrawal from the rental market. So the ELLIS Act is a California law, government code sections 7060 to 7060.7, and is part of the Richmond Rent Ordinance, which provides that it provides landlords a legal way to go out of the rental market business. The ELLIS Act was adopted by the California legislature in 1985 after the California Supreme Court decision in the case of Nash v. City of Santa Monica. For more information and detailed steps, because there are quite a few, you definitely want to look at that URL address at the bottom of the page. So the notice requirements for withdrawal from the rental market. So first, a tenant must be served with a written notice for withdrawal from the rental market, or a termination of tenancy. The owner must give the tenant no less than 120 days for the tenant to vacate the property if there's not a qualifying tenant who lives in the household. So at a minimum, it's 120 days. Not 30, it's not 60, it's not 90, it's 120. The owner shall provide a written notice to each tenant on the property, notifying them of the withdrawal from the rental market. Tenants shall be entitled to 120-day notice unless they are qualified tenants. Qualified tenants are entitled to a 1-year notice. So it's not 120 days, right? Which is 4 months, it's 1 year. If they are senior, disabled, have at least one dependent minor child living in the house, or are considered a low-income household, and have been residing in the unit for at least 1 year prior to the date of the delivery of the notice to intent to withdraw to the board. If the qualified tenant wants the 1-year entitlement, though, they must, within 60 days of the date of the delivery of the termination notice to the rent program, that tenant must return to the owner a notice of entitlement to a 1-year notice. So basically, they have to respond within 60 days of getting the notice, saying, I'm a senior, I'm entitled to a 1-year notice, or I'm disabled, I'm entitled to 1-year notice. All right, so returning withdrawn rental units back to the rental market. So for rent control properties that are being withdrawn from the rental market and are rented again after withdrawal, the following apply. If the property is offered for rent within 2 years from withdrawing from the rental market, the owner shall be liable for actual and punitive damages to any tenant displaced by the property being withdrawn, and they shall offer the unit back for rent to the displaced tenant. And that asterisk just says at the bottom, if the tenant has advised the owner in writing within 30 days of displacement of his or her desire to consider an offer to renew the tenancy, and has furnished the owner with an address to which that offer is to be directed. And again, so those actual punitive damages would come in the form of a tenant affirmative lawsuit suing the landlord for essentially what would be a wrongful eviction. So moving on, for rent-controlled tenancies only, all right, this is for only fully rent-controlled tenancies. For the first 5 years after withdrawing the unit, if the property is reoffered for rent, the property shall be offered back to the vacating tenant at the rent in effect when the property was removed from the rental market. An annual general adjustment rent increase may be applied if the tenant moves back into the rental unit. However, for non-rent controlled tenancies, the landlord must still offer the unit back to the tenant who is evicted. However, the rent charge can be set at a market rate. If the property is demolished, reconstructed, or offered for rent within 5 years from the withdrawal of the market, the newly constructed unit shall be subject to rent control. If the property is offered for rent within 10 years from withdrawing from the rental market, the owner shall notify the rent board and offer the unit back to the tenant who was evicted. So again, tenants essentially, in that case, for 10 years, have a first right of refusal to return if the rental unit is placed back on the market. All right, so we're going to briefly discuss the City of Richmond's relocation ordinance. So first of all, there are temporary relocation payments. The landlord must provide temporary relocation payments assistance when the tenant must temporarily vacate for the landlord to undertake substantial repairs, or if there's a governmental order to vacate the unit, or the tenant is forced to vacate due to conditions of health or safety. The notice of entitlement to temporary relocation payment must be provided with the notice of termination of tenancy. Relocation payment amount is determined by a resolution of the City Council. Excuse me. So these are the amounts for a temporary relocation payment for 2022. Talks about different types of expenses: hotel, motel, meal expenses, laundry, pet accommodations. So again, these are for the amounts in 2022. Hotel and motel is $168.15 per day per household. Meal expenses are $33.85 per day per person. Laundry is $1.12 per day per household. And pet accommodations are either $32.73 for a cat or $58.69 per day per dog per day per animal. And this is only applicable if wherever the tenant's staying temporarily, they don't allow pets, and so the tenant has to board the animal. Permanent relocation payment. So this is different. It's not temporary. These are permanent payments. So this must be provided to tenants whose tenancy is terminating due to owner move-in or withdrawal from the rental market, or ELLIS, or under extenuating circumstances due to governmental order to vacate or health and safety conditions. So the notice of entitlement to relocation payment must be provided with the notice of termination of tenancy for owner move-in and withdrawal from the rental market. The amount is determined by a resolution of the Richmond City Council. So these are the amounts for an owner move-in and withdrawal from the rental market. And as you can see, it's divided up by studio, 1 bedroom, or 2 or more bedrooms. Those are the 3 categories. And I won't go over the numbers exactly, but as you see, there's two categories. There's the base amount, which is the minimum, and then there's a qualified tenant household amount. And so you see at the bottom, a qualified, so that's a higher amount. The qualified tenant household amount is any household that includes at least one tenant that is a senior citizen, so that's 62 years of age, I believe, disabled, or has at least one minor dependent child. And I think it may be also if they're a low-income household, but I'm not sure. I'd have to double check on that. All right, so here are some important tips just generally on eviction. So self-help eviction is when a landlord locks out a tenant, cuts off the utilities, or otherwise takes their own actions to terminate the tenancy without going to court. Self-help evictions are illegal in California. A landlord must proceed with the unlawful detainer eviction lawsuit process and receive a judgment from the court. If the tenant does not vacate, the sheriff can evict with a writ or judgment in their possession. The second point is speak to an attorney. This goes back to my original point, which was speak to an attorney. Evictions can be highly technical. It is highly recommended to consider speaking to legal counsel to better understand the process and current law, and to possibly have the attorney represent you in court. Learn about tenant and landlord responsibilities and educate yourself about both California and Richmond eviction laws. Finally, no-fault evictions such as owner move-in and withdrawal from the rental market are complicated. No-fault evictions require special noticing, permanent relocation payments, and provide special or even temporary relocation payments possibly, and provide special rights to the tenant, such as the right to move back in at the rent paid when the tenant vacated the property, and protected status for qualified long-term tenants. Take eviction seriously. Definitely contact the Richmond Rent Program as soon as possible if you receive threats of eviction, warning notices, actual termination notices, or court documents for unlawful detainer. If you are a landlord, contact the Richmond Rent Program if you are considering issuing any of these notices or documents. The second point is the eviction process has firm deadlines, which, if not met, can lead to the tenant being evicted. They can also lead to the landlord losing their case, right? It goes both ways. So if an unlawful detainer complaint is received, tenants generally only have a certain amount of days to respond with an answer to the unlawful detainer. If a tenant does not file the answer to the unlawful detainer with the court within the allowed time, the judge, after getting a request from the landlord, may enter a default judgment against the tenant. For tenants, be a tenant in good standing. Prior to just cause for eviction protections in Richmond, tenants could be evicted without cause. So tenants should avoid giving the landlord a just cause reason to evict. That is all the information I have for this presentation. I want to thank you so much for participating and listening in. As I said before, a lot of this information is complicated. You definitely want to talk to an attorney or set up an appointment with us. You can call the Richmond Rent Program at 510-234-RENT or 7368. You can email us at rent@ci.richmond.ca.us, or you may visit us at www.richmondrent.org to set up an appointment. I thank you very much and have a great rest of your day. Thank you.